Yeah. Okay. Yes. Thank you, Roberto, and thank you all members of this last panel, this last concluding discussion. Indeed, it was fascinating. We could have gone on again for at least another hour or much more beyond that. But indeed, I'm happy that this has been a little contribution maybe in this ongoing dialogue. And we had foreseen in the program to now present some concluding remarks to connect the dots, but actually it was not necessary at all. You have already connected the dots here between the scientists and the lawyers. So just let us be extremely brief and just give a few little thoughts that we have taken away from the discussion over the 2 days, and which indeed are only just the beginning, or just not even the beginning. We have already started, but like a little point in a longer ongoing dialogue, which we need to continue, obviously, in all types of fora, universities and in the legal communities, in the scientific communities, basically everywhere, and get together. So the three, indeed, by way of just some very short concluding remarks, Ivano, Jean-Pierre, and I identified like 3 groups of challenges that came out of the discussions over the 2 days, and which indeed still need to be addressed. And these are, firstly, challenges related to communication. Secondly, challenges related to the use of science in climate cases from a procedural perspective. And thirdly, challenges related to the use of science in climate cases from a substantive perspective. So each of us will say just a few words on these 3 types of challenges. On communication, I don't hardly have to add anything. Christina said it all. Indeed, we started off the workshop with 2 questions. How can we, as lawyers, communicate what the law needs and adjust the language of the law to the scientific audience? And on the other hand, how can we, as scientists, communicate the complexity of climate science in a language that's accessible to the legal community and those engaging in climate litigation? And indeed, in the first panel, we have seen, and also in the second panel, it came out clearly, as Christina so eloquently pointed out again, the formulations, a goal, temperature goal. We all agree. Obviously, negotiators are very clear what it means to keep well below 2 degrees, striving towards 1.5. But the scientists say, well below 2, that's a whole range of scenarios. So the terms are the same, but the interpretation is different. So these are concrete examples of the necessity to overcome these maybe not really misunderstandings, but sometimes unclarities maybe in the communication. A second point which came up in the second panel was also on foreseeability, unforeseeable risks, foreseeable risks. They have a certain meaning under law, under insurance, in the context of insurance law, or under human rights law. But for the scientists, it's something completely different when a risk is foreseeable or unforeseeable, not completely, but they have different parameters, different criteria. So indeed, these questions need to be communicated. We need to talk about it, understand. There's a need to further clarify the respective meanings of such terms from both sides. And I just wanted to tell you that one of the members of our seasonal school said, well, why don't the scientists follow the example of the IPCC, and when they produce scientific reports on climate change, also add a synthesis report for the lawyers? I thought it was a nice way of putting it. Probably, maybe it's already done, but this was just, a voice from a young lawyer listening to the scientists. Another point, just to conclude this first group of challenges related to communication, what I found interesting to hear that one of the scientists said that the youth climate movement was able to mobilize public opinion in a matter of few months on the same items that we scientists have tried to communicate for 30 years. So that too, I think, was quite telling. Indeed, the science was there. And of course, we've used it and we knew about it. It was the basis of negotiations. But indeed, maybe it was not out there, and the youth are able, based on that science and based on the momentum, of course, that has been reached, to communicate. So there also communication between the scientific community and the youth, maybe the activists, civil society, make it more accessible. I think that would help. Over to Ivano for the second type of challenges.
Thanks, Christine. So the second type of challenges are those related to the use of science in climate cases from a procedural perspective, and also we could say generated to judges' attitude. Some of the challenges that might be interesting for future discussion or research and that were identified include, first of all, how can litigators gain access to scientific data and analysis, especially in the Global South. So we had an interesting overview by John and Lynn with regard to this important issue. The Global South. How can litigators and judges increase their capacity to use those data to support their legal arguments? And this also considering the more or less sophistication, as Monica Ferratinta was suggesting, in dealing with science in courts in the different legal systems. And help can be provided, as suggested also by some other speakers, by national science bodies in different countries, by transnational NGOs from Global South and Global North, which can be critical in bringing better science in climate litigation cases, or through scientific amicus briefs. That might be done also through always more and important precedents in the sense of lesson learning. Therefore, it will definitely be interesting to consider the circulation of arguments and the related science among the different legal experience in order to enhance the capacity of litigators and judges to use them. Another point made that might be developing is related to how a negative attitude among judges towards the use of science in legal cases can be overcome. So if I don't remember wrong, maybe that was Joanna Setzer and Annalisa Savaresi. We can start from Joanna, who mentioned in her presentation the famous Massachusetts versus EPA and the attitude of Justice Scalia. And we saw that there's already been a clear evolution by some part of the judiciary around the world. They might work also for international courts, as Professor Marjan Dubois said. The ICG's method of establishing facts and handling scientific matter might be improved, she said, and we are witnessing to an evolution in its engagement in general environmental cases. As she said, the ICG is almost ready for climate cases. An important tool to respond to those points might be scientific training for lawyers, judges, both in legal academic curricula at the university and focused professional training. Another important way of stimulating the dialogue between science and the courts might be provided by workshops like the one we organized last week with the members of the judiciary from over 30 countries and from each continent. And just for that, as Michael Gerard from Korea University noted, as the reporter of one of these judicial workshops, focused, as I remember, on the topic of the separation of powers in climate litigation, there is the possibility that if judges abdicate the responsibility to act in the faces of a crisis, that too could lead to a loss in public confidence in the judiciary. As we highlighted yesterday, there is growing concern in the public and the news media about the severity of the climate problem. Therefore, as an interesting finding from that discussion, there was also the sense by some of the judges that if the legislature and the executive have been negligent in not addressing the climate problem, possibly because they have been captured by the fossil fuel interest, then judges have not only the ability, but also the obligation to step in and prevent global disaster. And we believe the science will provide an important role in this. Sorry to make the connection with our previous conference. So thank you for your attention, and over to you, Jean-Pierre.
Thank you very much, Ivano. And my final contribution is about the role of the use of science in climate cases from a substantive perspective. And I think the 4 panels across the 2 days have really highlighted the important role that science plays in national climate litigation, in international environmental and climate-related litigation, etc. Several issues commonly arise in these cases around standing, justiciability, causation, attribution, and the determination of quantum in the context of remedies. And I think what the main thing that we highlighted in the last couple of days is that there is a role for science to play in determining each of these issues. In each of these questions, there is a role for science to play. One kind of particular issue that came out quite clearly across the sessions was the role of attribution science. and the fact that, basically both in terms of source attribution and single step and multi-step attribution processes, as well as extreme event attribution. And we saw kind of presentations around kind of the distribution of existing science to a legal audience that is starting to happen and that there needs to be more of. And in this context, I think the other thing that came out quite clearly is the importance of science for filling the evidentiary gap that comes across in many of these cases. A difference was recalled in a few of the panels, but in particular the third panel, between backward-looking cases and forward-looking cases, and the fact that science can play slightly different roles in those two scenarios, but also that we need more science and more accessible science in this particular field. Obviously, as a human rights lawyer, I was particularly interested in the human rights aspects of these cases and the fact that science can help establish both the seriousness of risk of human rights violations resulting from climate change, but also to substantiate the content of state and corporate obligations and to establish a causal link between emissions, climate change, and specific human rights violations. Again, more data is needed and more accessible data is needed, including at the country level, and access to these data is needed both for judges, lawyers, as well as others. So basically the 2 days have raised many questions. Many of these were addressed. However, there's many more that can be addressed. As Roberto said, we could have these conversations for hours and hours and days and days. So we will need to get back together. Hopefully in future, we'll also be able to have some of these conversations face-to-face, not only via Zoom. But that is, I think, our way forward is to continue this dialogue, and the past 2 days are only the start of that process. With that said, I did want to end with a series of thank yous, and I appreciate that this is the last few minutes of what have been a pretty dense 2 days, but please do bear with me. The few people that I want to particularly thank, and I do apologize if I leave anyone out, it is not intentional. So the first set of thank yous is to Christine, Bakker, and Roberto Buizza from the Scuola Sant'Anna for what has been an excellent collaboration over the last few months in the run-up to this event, as well as over the past 2 days in particular. Second is my colleagues at Bickel, so Ivano, Alogna, and other colleagues at Bickel for their work in putting this together. Besides Ivano, I also want to thank Alina Holzhausen, who's also on the screen, who will be helping us put together the report from this event, but also Bradley Dawson, Carmel Brown, and the Bickel marketing team. And in particular, I want to thank Liam Strahed, who is hiding behind the Bickel logo, but has managed to keep the logistics of this event going seamlessly, including dealing with last-minute stresses that always come up with any of these events, not to mention dealing with the many requests from us as the organizers over the past few weeks. I think it's an understatement for us to say that this event would not have happened if it wasn't for Liam. Next, I want to thank all the speakers and chairs over the last 2 days. You've been extremely generous with your time and ideas, and we're extremely grateful for that. You have sparked a lot of questions, a lot of ideas, a lot of inspiration for moving forward. And finally, I want to thank all the participants. Thank you for joining us, for asking your insightful questions, and for bearing with us in what we know have been a very heavy and long couple of days. We're delighted and honored to have had you with us. Okay, with that, thank you very much to everyone and have a great evening. Bye.
Bye-bye.
Thank you, Jean-Pierre. Bye-bye. Thank you very much.